The germane application relates mainly to Engineer John Barrot, who is before the court. Mr. Stephen Lell, who is also before the court.
So where are they?
Engineer Barrot is on my right. Mr. Stephen Lell is on my left.
Okay.
They are seated closer to each other. Your Honor, as part of housekeeping, and the two witnesses confirmed that they have tremendous respect for the court. They respect both proceedings and would always be available whenever needed by the court. Your Honor, Engineer John Barrot who is the outgoing Deputy Governor of Uasin Gishu County, exited the devolved unit and, Your Honor, if the investigating officer was before the court, we pray that he serves police bond, that is the witness bond, for summons directly upon Engineer Barrot, who is no longer within the purview of the county government of Uasin Gishu. We look at the bonds which were served, Your Honor. They were served through the county secretary. This defeats incredulity, considering that his departure from the county was pronounced very loudly before international media. And off the cuff, Your Honor, when these warrants of arrest were issued and flashed by the media, which is before the court, and we do not blame them at all, as breaking news, Your Honor might have come across such footages. The mother to Engineer Barrot, who is based in Eldoret, ordinarily over 90 years, was distraught because she thought that engineer was being arrested because he had inserted his fingers into the till of student funds. So what has occasioned this miscarriage of justice to the witness should not happen again if the IO serves Engineer Barrot directly, not through the county secretary, as you will see, Your Honor, from the forms. And for this, we pray that as a way of advancing administration of justice, the investigating officer be admonished on service of police bond. Engineer John Barrot is more than willing to testify, even if the prosecution was ready to pay. That is a commitment is made to the people who are in issue, Kenyans, and importantly, this temple of justice.
This court from lifting the thing or ruling.
Yes, Your Honor, this is our question. I think you asked him a sequence of questions. One of the questions is whether we are party to it. We are learning of the existence of it in this proceeding, so we are not party to it, we are not aware of it. Number two, Your Honor, it is our understanding that it is neither a stay of proceedings, nor does it stay you from lifting the warrants. It's our view that if you lift the warrants, you will in all probabilities render that application moot, because it doesn't stop you from addressing it as by way of proceedings.
Mr. Okay. Are you done?
Have I answered your question?
Yes, yes.
Thank
On behalf of the fourth witness, Mr. Edwin Bett, Your Honor, permit me to first indicate that he is a law-abiding citizen. He's asked me in particular to mention to the court that whenever called upon through the proper channels to attend any court proceedings, he will not hesitate. He has not been reluctant. And just like the three other witnesses, he equally got perplexed at the turn of events leading to the issuance of warrants of arrest as against him. Your Honor, he says this for a number of reasons. Number one, that whereas there were bonds that were sent to the county, there was communication with the office of the Director of Prosecutions, indicating the circumstances obtaining to just his ability to attend court then. The letter is dated 2nd of September 2024, Your Honor. Having presented that and having conferred with the office of the DPP, the understanding they had was that on that occasion, they would be excused from attending the proceedings. Your Honor, permit me to say that even as a law-abiding citizen, the reason why the law provides for procedural, certain procedural avenues for dealing with the matters is so that we don't find ourselves in this sort of situations. That pursuant to Section 144 and 145 of the Criminal Procedure Code, there is an obligation on the court to satisfy itself that the witnesses who are supposed to be attending court are in fact being deliberately obstinate. And again, that Section 145 spells out what needs to happen in the event of such satisfaction to the court. The position, my Lord, Your Honor, being that summons would issue for the attendance of such a witness. Your Honor, the issuance of summons is a legal process. It is to ensure that all parties are accorded a fair opportunity to participate in motions before a court. And why that is important is because of exactly where we have found ourselves, that warrants of arrest can then be issued. So for the court to be able to satisfy itself that there is that obstinance from a particular witness, then those summons ought to have been availed before you. Your Honor, from my practice as an advocate, in criminal trials in particular, there is need to ensure that all parties that are supposed to appear before a court of law are given a fair opportunity. And it's only in such circumstances, Your Honor, that in the event that the court then determines that a party is being difficult or non-responsive to the legal process, then the law determines how those parties are supposed to be dealt with. Your Honor, having said that, it should also not be lost on us that all the witnesses are leaders in their respective rights. They are parents. They have family members. In the event that this sort of narrative turns out on their name, it puts a lot of weight on all those people who relate to them. It is on that account, Your Honor, that we urge the court to issue a specific direction in relation to this matter so that there's parity of arms. And this, Your Honor, is based on legitimate expectations of the law. That for a party to attend court, then they must be served. They must be notified. And that service, Your Honor, I dare add, should be personal, particularly because of the nature of the consequences that would befall an individual in a criminal process. If I was to draw an analogy, Your Honor, if perchance summons were to be issued to this court to attend a proceeding in any other forum, and it is sent through the Chief Magistrate, Your Honor, it may be unfair to ask you why you did not attend the court. It may also be unfair to have put that responsibility on the Chief Magistrate to be able to then ensure that you attend court. I think the law puts and places personal responsibility on attendance of a court session, and so it's important that then we just adhere to what the law prescribes. Your Honor, that said, we ask that just like for the 3 other witnesses, the warrants that have been issued as against the 4th witness be lifted. The witness is in court and he gives
The name of the witness? I didn't get.
Edwin Bett.
The county secretary.
Yes. He is in court and is confirming that he will always be willing to attend any court session for as long as notice has been given to them. I must oblige, Your Honor.
Now, the IO confirmed that he is the one who had been receiving summons on behalf of all the county officials. Actually, the impression that was given was that the county officials are not willing to come to court. That was the impression. We did not intend to specifically issue orders against a specific officer, but the impression was that the county officials are not in court. When this matter began, that on 1st of July, we had to adjourn, and the court did direct that possibly we divert. The DPP can actually begin with the victims, the parents and the children. Yes, that was the issue. So the position was that the county officials are not willing to attend court in this matter.
May I confirm to you, Your Honor?
That is off record,
yes. Yes. May I confirm to you that that must have been a very unfortunate and wrong perception?
That was the perception.
Yes.
Yet, we are aware that 2 or 2 witnesses are supposed to come here. There are several, there are many.
Yes.
There are many witnesses.
And Your Honor, just also off the record, you'd imagine, because on that same date, we had a newspaper headline reading, "Lords of Impunity, those who don't attend court sessions." And so that is then what ignited social media. And you can imagine the sort of weight and pressure that that then places on these 4 law-abiding citizens.
So the county secretary, your client, was the one who had been receiving those summons. That's the point that I was trying to raise with you. Yes, I have confirmed.
Yes, Your Honor, they've talked about the previous events,
The previous
right?
events.
Yes, but
The
what
Mandamano issue,
Sorry?
I saw a letter about the Mandamano issue, the
Yes.
Gen Z protest.
Yes.
In your English, I'm told it was a bit more deadly.
Yes.
So your client was not willing to come to court because of that. Yeah.
Was put in a difficult position. Not
Before
that they
the
were not
letter.
willing to come to court.
We saw the letter.
Yes.
Yes.
Exactly. And so that's why, Your Honor, then, through the office of DPP, when such issues arise, it could be that we leave court today, Your Honor, and you give us a date for the hearing of a case tomorrow, and somebody is taken ill. I think the responsible thing to do is to ensure that that communication reaches the court, and there are avenues through which it reaches the court. That is the only point I think that we're trying to make.
So which is the avenue?
Through
the prosecution, of course.
Yes, of course.
Yes, yeah.
And so it is for that reason that when there was that communication, noting that these parties cannot address the court directly through a letter or something like that, they write to the person to whom they're supposed to be coming, because they're prosecution witnesses.
Because the court does not just wake up and issue summons and warrants.
Exactly. Exactly.
Yeah.
So, and that's why then it's necessary for the court to be satisfied.
The court also has a mandate to summon a witness. I believe you are aware of that.
I'm aware.
150 CPC.
Yes.
Yes. Yeah?
Yes.
So once a matter is in court, the court is actually in charge
Yes.
to ensure that there's justice on both sides. It doesn't become the mandate of a specific organization or body. The court actually presides over. That's why it presides over, to ensure that justice is done and the rights of all the parties concerned is safeguarded. So
Yes, Your Honor, you're very right, and I really, really agree with that position. Just to add that the way the law prescribes that
Yes.
is that then summons are issued to Eric Gumbo to come to court.
Yes.
Now, in the absence of summons being issued to Eric Gumbo to come to court, then again under Article 50, there's a chance that I could be put in a difficult position for something that I ought not to have been put under in the first place.
Mr. Gumbo, when that happens, then the avenue is like, it just the same avenue that the council did. The rush to court, the court suspended.
But, Your
That's what
Honor,
the council did,
Your Honor, is it not appropriate
Because
that summons first are issued?
The summons are issued, yes. But who
In
served
this
the
occasion, they were
summons?
not issued.
Who served the summons or the warrants?
Bonds
It is
were
not the
issued,
court, eh?
not summons.
Yes.
Yes.
No, at that part now, I wait the High Court, the High Court decision on that. The matter is now the High Court. I did state in my ruling that I want to go to the legalities of all those. The matter is now before the High Court. Let's wait for the High Court's judgment on that or ruling. Am I wrong on that?
Yes, Your
The
Honor.
legality of the entire process,
Yes.
we await the High Court's determination. The matter is now before the High Court.
Yes, Your Honor. I only brought it up to your attention for purposes of Section 145, so that then you also had a duty to satisfy yourself that that had happened.
Okay, thank
Yes.
you. The defense counsel.
Your Honor, I believe it's a defense stand.
Yes.
Your Honor,
Are we done with the witnesses?
Yes, yes, yes.
Okay. Guire?
Your Honor, firstly, for the record, I want us to be understood that it's in the interests of our clients and the case. I will have no indictment on that on the basis of service that they had left the county government. But on the presentation, Learned Senior, Mr. Kigen, my friend, and Mr. Gumbo, I take serious issue, Your Honor. Their witnesses may not have respect for you as you, Your Honor, but they have to respect the court. It insults the court, it insults us even as officers of the court, for the county secretary, for instance, to receive bonds, as he has confirmed he did, and he ignore court, and says, I will ignore until summons are served. That is not responsible at all. And then they want to show up here and say that they are law-abiding citizens. That is not responsible at all, with respect. Your Honor, it insults our position, even as officers of this court, when His Excellency the Governor, having failed to attend court, and rather than come mea culpa and say sorry to the court so that he explains the circumstances and warrants are lifted, that he shall now exact an apology from the court. You know, that was not a joke. That is one of those things that will even militate, Your Honor, against your exercise of this discretion. Your Honor, I will argue for the defense that let all of us here be treated equally as you have done. Our clients are the defense, but the witnesses that come, it doesn't matter whether you are in government or you are not. These people, Your Honor, have signed witness statements to appear in court. They have variously been served some bonds to appear in court. Your Honor, moving forward, today, forgive, Your Honor, so that we move forward. I want to believe that the act you did of issuing warrants was the only way that made them to listen, and that they have listened, they have learned their lesson, they will respect the court moving forward, and that we will have this matter heard without any hiccups. If it is under those circumstances, which I didn't hear them say, they offered an apology and clawed back. But if that is the apology, then for the defense, we agree, Your Honor, you may continue to suspend your warrants, Your Honor. If you lift those warrants, legally speaking, it's our position that nothing bars you legally to lift them. The High Court will be informed that the application before it has been overtaken by events, and Your Honor, we can proceed in this matter without any other interruption from any order. But Your Honor, for the accused person, we are happy that your gavel came down like it did, and we are here. And that there is now the fear of God on behalf of everybody, that all of us are equal here, and we will respect these proceedings moving forward to conclusion. We are much obliged.
It is our argument that indeed there is no question of our clients needing to respect the court. There is no situation of our clients needing to apologize to you. There is no context in which it can be said that we either insulted you or insulted the defense. It is just a question of what does the law provide. The law provides that you can only issue warrants when summons have been served, and that those summons were served personally, and that there is adequate time as provided for in the sections 144, 145, and 150 of the Criminal Procedure Code. For those reasons, Your Honor, we contend that there is indeed no room for choice other than to lift the warrants, and that the type of militancy Mr. Bwire is making that is not supported by law. That's all I wish to say, Your Honor.
Mr. Gumbo?
I associate myself with that.
Mr. Kikwech?
Thank you, Your Honor. Mr. Bwire said he had no opposition absolutely to what I applied, and to save court's precious time, I will not say anything further. Your Honor, there was this aspect of the prosecution saying that you do not have jurisdiction. I respectfully disagree. The order speaks for itself, and I will not want to say.
You had already
Thank you.
that. I'm making a ruling now. So I'm sorry again, we need to stand up for the ruling on this. So now that all parties are in agreement that the warrant of arrest be lifted, I do hereby see no reason to continue maintaining the same. The warrants of arrest that were promptly suspended on the 9th of September 2024 are hereby lifted, and the witnesses to abide by their undertakings to come to court as and when summoned and or bonded, either by the prosecution through the investigating officer and or the court, whether upon application by the prosecution, the defense, or the court on its own motion. I believe you are aware that even the defense can apply for witness to be called.
Yes.
Yes.
We do, Your Honor. And
So when that is
also-
done, I believe there will be no challenge to that no, it is our mandate of who to do what. So I feel that the witnesses to abide by their undertakings that they will attend court when summoned or bonded, whether by the prosecution, through the investigating officer and or the court, whether upon application by the prosecution, application by the defense, or the court in its own motion. As to the legality of the process, the same shall await the matter pending at the High Court. I don't know whether to call it an appeal or I'm seeing an application to the High Court. So I feel the matter pending at the High Court. Yeah. I believe all those all those issues as to the process itself shall await that. I don't want to comment on it now. Yes, so that's done.
We are okay with that, Your Honor. Only that.
So
I understand
even the
that-
apology shall await the
Yes.
judgment by the High Court.
That's okay.
I will have gone and then gone through the law as per your submissions,
Yes.
but because there's a matter pending before the High Court,
Understand.
I'll ask to call it a matter because I'm seeing a notice of motion.
Yes.
Yeah, the matter
But
pending
I was
before
just
the High Court.
wondering, Anna, whether then we are sitting as a parliament, because our understanding
Yes.
and our undertaking is that if they are summoned, they will come, and they will come, Your Honor.
Yes.
And if they don't come, we issue one. The reservations we have with your ruling, Your Honor, is if you say that even bonds should yield warrants, Your Honor, that's amending the law, and that, I
Where?
would rather you cross out where you say.
At the moment, no, I've not mentioned
You
anything
say
about the
bonds
warrant.
or summons, Your Honor.
No, bonded by the police, summoned by the court.
And I
So,
would rather summons, Your Honor.
whether summoned or
The
bonded.
summons cannot.
The IO can bond.
Okay.
I don't need to
We'll
get
deal with it
involved.
when it comes up.
I don't want to get involved too much
Okay.
until called upon. If at all they can't abide by the bond, then any party can apply the court to issue the appropriate summons of the bond. Yes.
Yeah, provided it's personal service, that we are okay.
The prosecution, personal service. Prosecution, how do you intend to serve the witnesses?
There should be an option. The law is very clear. We don't restrict service to personal service. Where it is clearly impossible to serve somebody in person, we can use other forms of service to get the person summoned to court.
Depends on whether you
Summons is not actually restricted to personal service.
So I believe we shall deal with that when it arises. Now that we have just but we are through with the issue of the warrant. The application by the county government. What I have before me appears to be submissions. I don't know whether you're going through it.
There was no application. I think that is what Lima wanted
They
to
were
say.
only to address me.
Yes, there's no application, there are no other sought.
That is a
No, but
official.
Your Honor, that's not guiding me, that is maybe explained to the court, but not.
Yes, Your Honor, to explain to the court. Probably
Yeah,
this,
briefly.
yeah, this is actually a new thing in this court. And I made that certificate pursuant to the sections in this piece of legislation. Which I'll divide this one. Rather than consider. before making moving the
The certificate, let me call it that, the certificate by the county government should not occasion an adjournment, having come in the course of the proceedings, and the witnesses have attended court and they are ready to testify today. The application can be canvassed, let me call it the certificate. The certificate can be canvassed in the course of the proceedings hearing, and it should not on its own occasion an adjournment when the real victims and the accused persons are present and are ready with the hearing. So let me inform the public that this court has so far set aside 3 weeks for the last 3 months. That's around 1 week per month to hear the witnesses that the prosecution have lined up, and any application shall be canvassed alongside or in the course of the hearing, except those that come from the prosecution, the defense, or the victims. So the upshot is that the hearing to proceed, and if you agree at 2 p.m., you can take 1 or 2 witnesses, or as you may agree. So we adjourn?
Your Honor,
Yes.
if we may get direction whether we'll be we don't have to sit.
I believe we are done with him. Take it quiet. You can guide. You can whisper to him that we are done. In fact, they can even leave the court unless they want to follow the proceedings, which is okay.
You forgot that you had hired me.
Is Mr. Lel? Is Mr. Lel?
You can consult with the prosecution.
Yes, I believe we are done with you. We have completed the warrant to arrest, and I've been informed that it's only the victims, some 5 victims, who are ready to testify today. So you'll wait for the bond or the summons or something like that on a different date.
Your Honor, before you pay, I just want to confirm the directions regarding the applications. We've seen